Welcome to Legal Limelight. Oh, no, this is not Legal Limelight. Oh my God. Welcome to the ESCA Legal Lounge.
Yeah.
It's like so auto, like
Yeah.
in my blood. So today it's not legal. Wow, all the acronyms are tying me up. Today it's ESCA Legal Lounge. Intentionally did alliteration, but it backfired today. So super excited. We have our partners Nicole and Angela here today. We are going to talk to you about licensing. The ESCA Legal Lounge today is about licensing. Bunch of L's.
A lot of L's.
So Nicole, since you're the licensing expert, I think we should start with you. What is your definition of licensing?
Sure. So in a licensing relationship, you have a licensor that owns some type of intellectual property that they want to license to a partner, a licensee, for a royalty or commission. We see licensing in a wide variety of areas. You see licensing of software. You see licensing of consumer product goods. A lot of the consumer product goods that we utilize on a daily basis are manufactured and sold to us through a licensing relationship. We see licensing through interesting brand collaborations and partnerships where one party wants to utilize the intellectual property of the other. So we see a licensing every day on a day-to-day basis.
Angela, how do you see licensing in the patent world?
In the patent world, I see licensing as something that you can do, again, as Nicole said, with if you want to partner with someone or collaborate with them and create intellectual property or a product, and then together you both will own it. But also it is something where you can use it if someone else needs or wants your technology to acquire your technology or rights to parts of your technology to use them in their product and get a license for that. And it also is a great asset at times for litigation and settlements with patents.
Nicole, why is licensing important for brands?
It's important for a number of reasons. One, it allows a licensor to go into new categories with very little risk. So a licensee bears a lot of the risk and a lot of the costs associated with manufacturing and packaging and promotion and advertising and holding inventory. The licensor has a more passive role in that they're just licensing their IP. So it allows brands to go into new product categories and new markets with very little downside. In doing so, it increases brand awareness, exposes new consumers to different categories that the brand previously did not have. So there's tons of upside associated with licensing for both the licensor in spreading brand awareness and for the licensee because they're making most of the royalty or the commission that's associated when there's a sale.
It's amazing. And we saw some of our clients do some licensing deals this week. Angela, from a patent perspective, where does licensing come into play from a brand perspective? How do you usually see it from advising brands?
From a brand perspective, licensing is something that you need to do strategically with patents, typically, especially if it's licensing technology you developed in-house. You want to make sure that your company's brand and your products are protected prior to actually giving people licenses to it. And typically, if there are features which are what we call differentiating or really make your product stand out and different from others, you probably don't want to license it unless you're to the point where it is something that has been adopted by many in the industry, and maybe there are other variations of it, or you can do it other ways, not only the way you're doing it, but typically if it is something that really is specific to your brand to make you stand apart from others, you don't want to license it to others because then that gives them access and could cut into your market share. But if it is a product that maybe you are not using as much or not as much of a focus of your company because it has shifted or isn't aligned as much, that is a great time for you to take that IP and patents and help to monetize them through licensing.
I love that you basically said you can use it in a strategic way to really corner your place in the market, which is what a patent is. It's, gives you a short-term monopoly. But from a trademark perspective, I see the overlap with design patents and trade dress a lot. Trade dress is a subset of trademark where the purpose of it is to indicate source. So basically, when you see a Birkin bag, but just by looking at it without needing the Hermes name, you can immediately indicates to you who produced that. And it's very interesting as you talk about design patents. How can brands leverage design patents to protect their brand?
With design patents, it really does come down to the fact that when you apply for a design patent, it typically is because you want to be distinctive and you want to stand out in your market. And by filing that, it gives you that protection and more of that exclusivity. In that case, it typically isn't as likely that you would want to license your product because at that point, you really want to make yourself more differentiating and to really make your brand stand out.
Do you feel that patents are an underutilized tool by brands?
I do. I was actually looking at something this morning and I was thinking they got a utility patent or applied for it, but I was thinking, why didn't they go for a design patent? The cost is less. It typically gets granted quicker. Therefore, you have it in your arsenal and you can actually use it quicker than a utility patent. And I just feel like for the overall aesthetics, especially of consumer products, you really need to think about that as one of your ways of getting protection.
Yeah.
I feel like the fear is they think brands are expensive. They think that patents are expensive and will try to go other routes or skip the patent route completely. So what's your advice to brands that are starting out that are evaluating all of the different IP tools? What's your advice to them when considering and evaluating whether a patent is going to be helpful?
I think my advice is that if there is some utility to your product, you should definitely look into a regular utility patent. If there is aesthetics that go with it, or you think that the design is different and will stand out, you should also be looking at the aesthetics and seeing if a design patent may be a good option for you, because it really is a tool that I have seen lately not being used as much to get some protection. And really the cost of it is you're looking more along the lines of filing maybe like 3 trademarks or so in the scheme of things. When you look at that and part of your overall branding plan, what the cost really isn't significant compared to just having that overall protection and another protection in your toolbox if you do need it.
How long is a patent good for? When do you need to renew a patent?
So patent, a utility patent, it's 20 years from the filing.
Wow, that's a long time.
Yes, and you don't always get the patent right away, right? You're not going to get the patent for at least probably 2 or 3 years. But then a design patent, you could get quicker and it's good for 15 years.
Got it. Got it.
Nicole, you have both in-house experience and outside counsel experience. What is your experience with licensing? And I want to ask you specifically, what's your favorite part about it?
Ooh, my favorite part about licensing, I've been very lucky to work on a lot of licensing relationships that I get to see every single day, either walking down the street or somebody's wearing it, or it's on a TV show, or it's on a billboard. So that is probably my favorite part is when you're in a licensing relationship, you're kind of going from soup to nuts. Like you're going through the initial due diligence phase of finding the right partner for you, the right licensing partner through exchanging memorandums of understanding, your license agreement, and then maintaining the relationship, which is also a lot of work. Sometimes people think, done my licensing agreement, I'm going to stick it in a drawer and never look at it again. But there's lots of ongoing kind of rules that you need to abide by and compliance. But that is definitely one of my favorite parts is having been through the entire process, seeing all of the samples and the prototypes and the launch, and then seeing it out and about is definitely one of my favorite parts.
Do you have any war stories?
Horror stories or war stories?
I would
I have both.
say.
Well, I think, like I said, a big part of managing the licensing relationship is there are lots of rights associated. And so you have territorial rights and restrictions, you have exclusivity rights and restrictions. And so sometimes licensors will have a huge portfolio of licensees, and issues can arise when there's not, very good diligence or monitoring of what your licensees are doing. Sometimes they can go rogue and sell to retailers or accounts or in areas that another licensee has rights to. So not only can the licensee be sued, the licensor can be sued. There's all types of breach of contract issues that can come up. So there are lots of war/horror stories that emanate from that, because you really need to be mindful of your licensing portfolio and who maintains rights to what.
So, from what you're saying, like I see this in my head. This is not just you sign an agreement and you set it and forget it.
No.
You said maintenance, there's probably deadlines. So what's your advice to companies procedurally and how to manage licensing, whether it's in-house or with a firm?
First, do your due diligence on the partner, on the licensing partner. Make sure that their existing licensing relationships are in good form and in good order. And make sure that you're talking about all of the business terms before you put pen to paper. There are so many times where you've talked about the big highlights, territory and where you're selling and the licensed products and the royalties, but you also have to talk about not as sexy issues like who's taking responsibility if there's a recall of the product, who's owning all of the intellectual property at the end of the day, even though both parties put their hands on it. So making sure that the initial phase before putting pen to paper is really, really thought out. And then making sure that that agreement is reflective of that is super important for my clients. And I've done that both when I was in-house for a long period of time and in the way that I counsel my clients now.
Angela, do you have any patent licensing horror stories, or do you know of a good one that lives in your head?
I mean, I think that just from the standpoint that when you get engaged in a licensing agreement, usually in the beginning, it is usually something you're working towards and the parties get along well. And I think as time goes on, like Nicole said, how there's maintenance and everything, then the strategy of one or both of the companies could differ as time goes on, the actual usefulness of it. So I've seen patents that were jointly developed by companies and there's an agreement in place, like Nicole said. And in terms of the agreement, I haven't seen any crazy issues or anything, but then it comes to the point where, okay, we have to decide what we're doing with it. And then one company doesn't want it. So then they have to send it to the other company because they might have a right to review it before you actually abandon the patent or don't move forward with paying fees on the patent, because patents do get pricey as the longer you have them. Once you pay the 11-year fees for it, it's just a huge expense, and you multiply that for big companies. They do like to cut those patents at times. That needs to just be really ironed out and have that in an agreement, I think, because that is where I see where it could get messy down the line.
I would say not even just specifically a war story. I'll say my main takeaway and the most important thing to remember from an IP perspective. The most important takeaway from an IP and trademark perspective of licensing is this: make sure that you have clear ownership of whatever it is that you're licensing. People think, oh, I'm going to license this thing, and they have no clue what they're licensing, what the scope is, and if they actually own the thing that they're licensing. So the first
Correct.
thing to do is you're getting into a new licensing deal, and let's say you're doing you're a celebrity model, so you have a trademark protected for your entertainment and modeling services, but now you're doing clothing. You cannot, for two reasons. You can't, one, assume that you can use your name in that category,
Yep.
because if it's a common name, someone may already have the name trademarked.
Yep.
So you want to work with a lawyer on a strategy if that's the case. And number two, you'll want to make sure that the licensor has clear ownership of it. We see situations all the time where the licensee goes ahead and registers the IP in the name of the licensor because they missed this one thing.
Yeah. And oftentimes you have licensors doing two things in a license agreement. One, representing and warranting that they own whatever the intellectual property is. And two, also representing and warranting that it doesn't infringe upon the rights of any other third parties. So when you have an issue that comes up where a licensor is licensing IP, but perhaps is not the actual valid, truthful owner, they could be sued by their partner for breach of contract, for violating reps and warranties, and they could be sued by a third party for infringing on their rights. So you really, like Francesca said, you have to make sure that you're buttoned up before you're licensing your IP.
Yeah, actually, can I jump in there too? Because I just thought of something. Also, when you do these agreements, if you do update the agreement or change entities or attempt to maybe rewrite it because is an entity change, you should make sure you review all of the terms of the agreement. Because I have seen where there's parts of the agreement where the reps and warranties that now are not actually true. And both parties are signing, both knowing that there's litigation or there is an asset that's being contested or was potentially invalidated but settled. And there's just issues that have come up since the original agreement. And now you're just re-signing the same agreement, but that's actually not true. So then that just opens up another can of work, that expands past the intellectual property part of it, right? Like the part of my expertise, it goes more into probably Nicole's expertise. Then, okay, how do we figure this out? And it's going to be also potentially local laws of where you're actually signing the agreement. And that's just, that can become really messy and really complicated.
Yeah, it's constant diligence and constant monitoring.
Yeah.
Wow. Yeah, when we hear the word licensing, I think people think it's a straightforward process. You partner and you have these some business people may think, oh, you have the business terms and you have legal terms, and legal terms are boilerplate. But as we see time and time again, a lot of the times when people come to us, it's when those terms weren't drafted well, and you really need to work with legal counsel who is experienced in this area to protect yourself, especially because these partnerships, most of them, the purpose of them is to promote them. The purpose of them is to be big, is to be global. So it's not something that's going to be something so small and one off. That these are big deals.
Yeah.
So
and both parties have skin in the game. Absolutely.
Mm-hmm. Go ahead, Nicole.
No, I just said, and both parties have skin in the game. So both parties are incentivized to make sure that they're complying with the agreement. and that they are, on top of all of the requirements that they're obligated to abide by throughout the entirety of the term. The good thing about license relationships, though, in some instances, and primarily with my clients, which are consumer product good companies, the license terms are usually short. They're 3 years or they're 5 years. And so and that's usually maybe just a few seasons. So it's not, long 20-year terms where you lock it in a drawer and you forget about it. Like, you are always meeting with the partner, staying on top of what your obligations are. You have a calendar, you have guaranteed minimum. So there's just always, dates and gates that you need to hit.
Yeah. But I would think that too, if it's longer, especially when you get through to the financials of it and how not like businesses change, markets change, that also creates problems when you're going longer than those short-term type of license agreements.
Definitely. And so many times partners end what was otherwise a good relationship because they have a better partner waiting in the wings that are offering them, more of a royalty, more of an upside. And so, things are constantly evolving in the industry that, sometimes you do jump around from partner to partner depending on what your needs are at that time.
Makes sense.
Yeah, no, this was great. I feel like there were so many gems in there. So if anyone has any questions, we are live. Feel free to comment. Also, you can, if you're watching the recording, still comment. We watch our socials, so we're happy to answer your questions in the next live. But otherwise, thank you. Thanks, Nicole, and thanks, Angela, for all of your words of wisdom around licensing. What's the best way that everyone can get in touch with you, Nicole?
You can email me, nicole@esca.legal, or you can follow me on Instagram at Nicole Dolgan, ESQ.
Yay.
And do both.
And Angela? What about you, Angela?
You can email me at angela@esca.legal, or you could follow me on Instagram at Your Patent Girl, or even on LinkedIn as well.
Yay.
I'm under Angela Cox.
Thanks, guys. Okay, I will see you all. The ESCA Legal Lounge, not Legal Limelight, is here every Monday. We're here at 1 o'clock Eastern Standard Time. We stream across as many channels as the software will allow us to at the given moment. But you can always watch on Instagram, LinkedIn, Facebook, and the recording's always posted on YouTube. So thanks, everyone, and we'll see you next week.